it's not yet. Okay. Thank you for joining us, everyone. So, this is Women of Color in Cannabis. This is our September meeting entitled Expungement 2020. I am Lo. I'm a founder of Women of Color in Cannabis. It's my partner there, Patricia, and our other partner back there, Javon, and this is Sammy. So thank you guys for being here today, and this is our speaker, Jennifer.
How are you?
So today's discussion is going to be about that new expungement and decriminalization bill that was recently passed. So has anyone heard of that bill that we're referring to? You have? What about in the back? Have you heard about that new bill? Okay. So if you were like us, you were really excited when you saw that this bill passed because you were like, great, we're making some headway. But I don't know if you guys kind of saw that fine print that said process won't be completed for up until a year. A lot of people didn't see that, didn't know that. So they're thinking, I can go around smoking outside now, you know, everything's new and different. It's fine. And that's not the case. So we're here to give you guys a little bit more information about what that decriminalization bill looks like. So first we're going to introduce Jennifer and have her give you guys a little bit about her background. She is an attorney, so go for it, Jennifer.
Hi, good afternoon, everyone. Good afternoon, everyone. Can everyone hear me?
Okay.
So I'm Jennifer Norman. I am a practicing attorney in Queens, New York, mostly, but throughout New York area. I have been practicing for just a little over 10 years, and my primary practice is in criminal defense. I am what you would consider a public defender. I do work for Queens Law Associates in Queens, and I also maintain a private practice. I've been working with QLA for the entire time I've been licensed to practice, so I started off defending violations, and I've moved up to everything up to B felonies, so drug arrests, violent crimes, nonviolent crimes, things like that. And I've had the pleasure of working primarily with youth at times. For about 2 to 3 years, I was working primarily with 18 to 21, and a lot of the offenses I saw, a lot of the arrests were for marijuana. So I have a lot of knowledge and insight to bring to that issue also. Yeah, I think that's mostly it. I've gotten very interested in the marijuana reform, cannabis reform, because we should really refer to it as cannabis. But I've gotten really interested in the cannabis reform nationwide as well as in New York and how it impacts communities of color and how the restorative justice comes into play where it's $1 billion industry for everyone else, but for our communities, there's still a disparity in the number of arrests, the availability of education, access, and business capital for our community. So I'm very excited to be here, and thank you for inviting me.
Thanks for joining us. Okay, so we're going to start with the basics, which is how do you even access your criminal record? So let's say you're unaware of what your criminal record looks like. Do you have any past infractions? I'm not sure how many of you are familiar with the criminal system. I'm very familiar with the criminal system. So, like, if you have an ACD, did that kick in yet? Can you tell everyone what an ACD is and how those usually work?
Yes. So, an ACD is an adjournment and contemplation of dismissal. Those are basically non-pleas where the judge will tell you to stay out of trouble for a certain amount of time, be a law-abiding citizen, and your case will be completely dismissed and sealed after that time period. For non-marijuana, non-cannabis crimes, they would be 6 months. But for cannabis, the marijuana ACD is a year. So they tell you to not get arrested for a year, stay out of trouble, and in a year the case will be dismissed and sealed. That is what most people will take because it seems like, all right, I'm just walking away and not thinking about it again. However, it does come up many times as an open case, an open drug case, and it can prevent you from getting student loans. It can prevent you, it can have other civil ramifications as far as, you know, housing, things like that. If you ever get stopped by the police, they can see that it's still open. They can even see if it has been closed.
If you're a college student, you can even lose your financial aid.
Right.
Which was
because
something I didn't know.
It's a drug arrest.
Yeah. Be careful, kids.
So a lot
how
of
do you
times,
access your criminal record? So maybe you've gotten a couple ACDs, you've been stopped by the police, you were somewhere you weren't supposed to be, you were smoking or maybe it was possession, whatever. You have an ACD. How do you access your criminal record and know where you stand today?
all right, so I had to make notes on this because basically the easiest way to find the website is to Google how do I get my criminal record, but it's criminaljustice.ny.gov. You go to the record review. So the actual link is criminaljustice.ny.gov/OJIS/record review.htm.
Can you run that back one more time?
One more time. And like I said, the best thing to do would be to Google My Criminal Record New York.
Okay.
But it would be criminaljustice.ny.gov/OJIS/record review, no spaces, .htm.
And I'm going to interject really quickly. So I just want to introduce you all to our second speaker and thank you for joining us. And apologize if I butcher your name. Just correct me. Okay. Shatad Floyd.
Yeah, you said it perfect.
Yes. Okay, so this is Shatad Floyd. He works with the mayor's office, and just like how we had Jennifer introduce herself, we're going to give Shatad some time to introduce herself.
Okay.
Tell us, I can take that.
There you go. Good.
Tell us a little bit about your work with the mayor's office and how you kind of got started in the marijuana or cannabis industry, however you like to call it.
Okay, cool. So as she said, my name is Shatad Floyd. I'm currently the Director of Government Affairs for the Mayor's Office of Criminal Justice. I've been with City Hall for a little over 3 years now. Originally sort of got into this space, had a fellowship with the state legislature, so happened to work for the Judiciary and Corrections Chair. So from that point on, ended up getting recruited by the City Hall, and I worked in Albany for the past 5 years. Came down here for a role with the Mayor's Office of Criminal Justice, and have been enjoying my time. Our office ran the Cannabis Legalization Task Force and sort of coordinated with all the other city agencies. So that's how it also brought me into contact with, like, obviously Javon, but I worked with her before that point too. So,
Okay.
And you know, obviously this is a big issue that pretty much sort of harms primarily communities of color. Like 87% of the arrests have been in Black and Latino communities. So, you know, that's what my passion is about, and sort of righting those wrongs.
Okay. So the question that Jennifer was answering for us is, how can someone access their criminal record if they wanted to see what infractions are still on their records and which ones have been sealed?
Yes, so when you go to that website, you have to request a personal record review. Sorry.
You're good. I tried one to call that,
So you have to request a personal record review. You can get a unsuppressed one, which shows ACDs, closed cases, sealed cases, or you can get a suppressed one, which shows your current actual criminal record. You need to schedule an appointment to have your fingerprints taken because they have to do it by fingerprint. It also costs $63.50. There's also a possibility, if you cannot afford that fee, that you can get a fee waiver application packet. They send that to you in the mail. You have to send it back. It takes about 7 to 10 business days once you've completed all the applications and the request for your records. And then they'll mail it to you. They'll mail your record to you. The other way would be if you do have contact with the police and you have a case that's either pending or closed, you can ask the attorney that handles your case. So if you get a legal aid or a defender attorney like the office I work for, you can ask them, can I have a copy of my rap sheet? And they will give it to you, but they might ask why you need it because you shouldn't, share it with anyone who's asking for it. But if you just tell them, I just want it for my own personal records, they can make you a copy, and then you wouldn't have to go through that whole process. But for those who are not having contact with the justice system, you'd have to go through this website, the criminaljustice.ny.gov.
Okay, so Shatad, let's ask you a question. So we've accessed our criminal records. We see that our ACDs are in effect, and we're told that these shouldn't appear in a background search. What does that mean on the shouldn't? What are the instances in which a sealed conviction may still appear in a background check?
Now, are you referring to broadly, or are you referring to specifically in relation to the new decriminalization law?
Let's do broadly and then specifically.
Okay.
Yeah.
So broadly, until your ACD is complete and like you've done all of that programming, that record will remain. There has been legislation that's been introduced It has not passed both houses. That sought to sort of kind of almost function as like a initial ceiling prior to, so that way you don't have to deal with any of the collateral consequences in that gap time before you complete all of your programming when the ACD is officially finished. So as of right now, that's just going to be out there, and there is no sort of remedy for that. But in relation to cannabis and the new law, right now the new law sort of assumes that DCJS or OCA or whomever is handling your records, they will remove any of the penal law like 215, Article 215 charges that you got for either possession of up to 1 ounce or possession of up to 2 ounces, sort of in this gap period. And then beginning in July, the end of July of 2020, that's when the localities and other law enforcement agencies should actually begin removing those records internally and sort of like marking and flagging them as being listed as expunged. So for like the beginning of that process, it will just be sort of like a label saying this is now expunged, and it won't be the physical destruction of records. That will require a separate motion before the court in order to have the physical destruction of those records. For most people, that's probably above and beyond what they actually need. But at the same time, if you want to exercise that right, you are absolutely empowered to do so. And while you didn't directly ask this,
we have several questions.
Yeah. Okay. So I can pause.
Just a note about ACDs. In practice, if I do have someone come in with a marijuana case, cannabis, I'm sorry, but if someone comes in with a cannabis case and they are offered an ACD, I usually ask the judge to impose a ACD under Penal Law 160-55. So the 160-55 is the 6-month ACD, and that is what we call a regular ACD. Sometimes they want the client to work for it. Often I ask them to give me their student ID or something that'll show that there'll be collateral consequences if they take the marijuana ACD, which is the 160-56, I believe. So I ask for early sealing. Maybe they'll want, the court will want a day of community service in exchange for early sealing. Often I try to just argue that the client deserves early sealing because they're a good student or because they don't want to have consequences with their job or finding a job. So often just asking the attorney who stands up on your case, which would probably be a public defender at the time when you're first seeing a judge, just asking them saying, I'm a student, I work for such and such or so-and-so, and it would be great if I could get it sealed early. What is the chance of doing that? Because often it just comes down to asking the judge for it, and the district attorney often does not, is not in opposition to that. So it really just comes down to just asking for it. You can get a 6-month ACD. You can get sealing upon 1 day of community service or something like that. So yeah, that's just how I deal with it in practice to avoid those collateral consequences for my client.
Can I audience question? You have to ask for it. Why is it not an automatic where the attorneys would advise, because most attorneys don't advise you that you have that option of doing an early sealing, or that there is any difference, or that there are even consequences to accepting an ACD. So why is it not just offered? And is there, I guess this second part is for you, Shatad, is there any plan to change that?
That's a good question. All attorneys practice differently. All clients maybe give their entire story. Like I ask if my clients are students or if there any reason that they can give me that I could take to a judge. Judges are often different. I'm not saying that every judge will offer early sealing or that every judge will allow a 6-month ACD as opposed to a marijuana ACD. So it really just comes down to who you're in front of, the volume of cases they have. A lot of times you tell people, okay, if you stay out of trouble for 12 months, the case will be dismissed and sealed. And they're like, cool, great, not a problem. And they just, walk away with that, and that's fine. Like I said, having the experience of dealing with youth primarily, I'm always looking for the better option or the better disposition, the shortest amount of time or the smallest obligation that they might have, because getting arrested is already a traumatic experience. Sometimes I say, judge, this person was arrested, they spent 24 hours in a cell or going through the system. Haven't they suffered enough? You know, and oftentimes the judge will say, yeah, that's fine, and almost dismiss and seal it immediately. All judges are different, though.
Yeah, so I was saying that obviously when the session begins back up in next January, it could certainly be a time where individuals can push for more reforms to the ACD process that would initially grant the early sealing rather than having individuals wait. Like I said, that there is sponsorship in both houses, so at least there's an appetite there within the state legislature.
And you mentioned the bill. What is the bill? Do you
I will have to circle back up. I don't know the number off top, but it's like Dan Court carries it.
Okay. So next question for you, Shatad. You spoke a little bit about a timeline. You mentioned June 2020. So can you explain what that timeline looks like and the breakdown? So I know there's a kind of like an automatic temporary sealing, but then there'll be actual formulation of a real concrete plan that will actually break down how these experiments will work. So can you speak to those two parts and the timelines for those two parts?
Yeah,
Did
so
I understand my question, by the way, or should I say it again? Okay, so right now there's no legit structure or formalized plan that says this is how New York State's going to go about expungements. So what I'm asking is currently what's the process? So if this is something that's technically started, what do they mean by technically started? What does that look like? And what will that actual plan look like? And maybe they don't have what that actual plan look like, but what is the timeline? So for right now, we'll be doing these temporary expungements until October, and then we foresee in February having an actual formalized plan. So that's kind of what we're looking for, some timelines.
yeah, so obviously the law went into effect, at the very end of August of this year. At that point, DCJS and obviously the courts have not begun identifying all charges that were marijuana related like throughout its history and sort of making everything wasn't going to be paper or electronic record. So what they did, recognizing that sort of deficiency, was if individual client or any person needed to have their record pulled, when that DCJS search is done, DCJS will sort of remove those marijuana-related offenses from that record, so that way it doesn't get sent outward to employers or to whomever. Over the next year up until July 29, 2020, they are going to begin a process so that way they can notify law enforcement agencies and individual municipalities on how they can actually abide by those guidelines. So at this point, obviously, we have not received information for like what New York City will be doing, but we do know that ultimately NYPD and other law enforcement throughout the city would need to be aware that they're not supposed to transmit that information, and internally they're not supposed to look at those records either, and they should be marking them as digitally expunged. So like how they do that, we will find out soon, in probably the next several months. I think DCJS and OCA are a little bit busy with bail reform, and then they'll probably circle back to this. But at that point, we should have like a full concrete process. For many people, I feel like the automatic vacature or this sort of intermediate measure will be enough. For folks who are immigrants, they will need to have a motion filed, just because the automatic sealing is not enough to ensure that they don't face sort of collateral consequences related to their immigration process.
So this is a general question for whomever wants to answer it. So what's the difference? I'm not sure if you guys have noticed, but we're seeing expungement, like an automatic expungement, and then actual expungement. So what's the difference in those two terminologies?
So New York doesn't have an official expungement process, like it's not in the Constitution. It really functions more like a regular sealing of records. So what they're doing in the automatic process is really comparable to a sealing, where the record is sealed, the law enforcement agencies are aware of it, but it's not. True expungement requires the physical destruction of those records. In order to have a true expungement, one would need to file a separate motion to get the physical records destroyed by all of those agencies.
Does everyone understand those two demarcations? Yes, you have a question?
And I also just want to add to that, the vacating judgments. So how does that play into this? I think the law that passed also created a process potentially to vacate certain judgments.
When you say judgments,
Like,
convictions?
yeah. So when I say like vacated judgment, that's like the language of the law, I guess.
Right. So when you say judgment, that brings to mind more of a civil consequence. But when it comes to convictions, as was said, you would have to file. So automatic expungement means the criminal justice says DCJS goes in and wipes the records themselves. However, the physical records, you would have to put in a motion for those to be destroyed. New York already has an expungement, but more of a sealing provision in the law. Whereas if you have 10-year-old convictions, if you have either 2 misdemeanors or 1 felony and 1 misdemeanor from over 10 years ago, and you've been a lawful citizen the entire 10-year period, you can put in a motion and request that those convictions be expunged, and that you fill out an application, you present it to the court where the conviction took place, and upon seeing good reason, they will expunge those convictions. So they'll seal them. An issue with the sealing versus expungement is that sealed records can be unsealed. So that's when putting in that motion for it to be destroyed, fingerprints, all records of it being destroyed, that's when that comes into play, because it's very important that if it's gone, it's gone. Just like an ACD, when they say it'll be dismissed and sealed, yes, but it can always be unsealed in order for the district attorney to know that you've had an ACD and so not offer you another one. So the current decriminalization law is about expunging B misdemeanor offenses as well as marijuana violations from your past, and those can be at any time. There's no indication that there's a number that they'll stop at. So if you've had 3 or 4 or 5, technically all of those should be expunged automatically. But to have your physical records destroyed, that would take a motion and a request to the court where it happened. Yes.
Well, just a follow-up to your question about physical destruction. If I recall correctly, there was a flood at a facility maybe about 2 years ago that destroyed thousands and thousands and thousands of records. Is that, I mean, I think the records were actually destroyed because of war and that.
But I think that those were Supreme Court records and it was an off-site archive.
Right.
Well, that I'm unfamiliar with that issue. When we talk about physical records, obviously we mean the paperwork, right? We also mean in the system. So for the records to be destroyed or erased in the system as well, you would have to put in a motion. Like I said, I'm unfamiliar with that incident.
Any other questions?
Can you go into what the B misdemeanor is that you
Yes.
what that actually means?
Okay, so again, I made notes about that. So ordinarily, under Penal Law 221, the section that governs marijuana or cannabis offenses, 221.05 is the unlawful possession of marijuana. That's a violation, just meaning you have it in your pocket. Maybe it comes out due to a search incident to lawful arrest, or you have it in the house, and maybe if a search warrant is executed, it's there in the house. It's not open to public view. It's not burning. You're not smoking it. That's just simple possession. That up to now has been a violation and continues to be a violation. And then you have Penal Law 221.10, which is the possession of the possession of 25 grams or less, and possession of marijuana that's burning or open to public view. That, up to now, is a B misdemeanor. So with a B misdemeanor, you can get up to 3 months in jail. Often that doesn't happen, but that was the penalty. That is now going to be referred to as unlawful possession of marijuana in the first degree, which is also a violation. So if you do have a B misdemeanor conviction from the past, that should be expunged. If you do have a previous marijuana violation on your record, that should also be expunged. With violations, often they're sealed after a year as long as you stay out of trouble, what's called a conditional discharge period. You stay out of trouble, it gets sealed after a year, and it's a violation, so it technically doesn't appear on a criminal record anyway. But those, just like we talked about, would be completely expunged. They wouldn't appear on any record. Now the law is that it's not a crime until you're in possession of 2 or more ounces of marijuana. So
I have a question, a separate
Yes.
question. So, if someone had less than an ounce, but let's say there was a scale in a baggie, or several baggies, it's now like intent to sell, right? Or that can be miscued as intent to sell, and would that would that also still be seen as a violation because technically the actual cannabis that the person has is less than an ounce, or because of that scale and those other ancillary things, it now would that increase
Right.
the charge?
So when you talk about scales, baggies, things like that, now you're talking about a different charge, which is possession of paraphernalia. So that could be a different charge. Oftentimes, when you're entering into a plea bargain, they want you to plead to the top count. So it wouldn't be the B misdemeanor marijuana possession, but if they charge you with the paraphernalia, that could be an A misdemeanor. Again, plea bargaining would probably come down to the violation and a fine. So a violation is still an arrestable offense. You can still get arrested for the violation, and instead of getting a ticket, and ultimately have to pay a fine or get an ACD or a few days of community service. But the new law, as it's written, as I saw the bill that had language crossed out and added in, it didn't address like a paraphernalia charge. It basically just addressed the possession of cannabis charges.
Okay. Another question, unless someone has Pat.
I saw you shaking your head, and she's like, it didn't address the paraphernalia.
That was just an agreement. That was just an
Was
agreement.
that? Oh, okay.
Honestly, drug paraphernalia never came up in the conversation, and
Okay.
I don't see that also coming up in the foreseeable future. Just because, like, most of the time, I mean, particularly scales, not so much as baggies, but more often than not, many people are going to associate you having a scale with like you running a full-time operation.
Right, and that's felony.
Yeah.
Okay.
So, like, generally speaking, the legislature is probably never, even when they do legalize, are not going to sort of allow folks to just be walking around with scales.
Okay.
Just to be real.
So on the topic of charges, can you discuss the charges that are applicable to this new expungement period? For example, if you have several charges, I think you briefly mentioned that there may not be a cap. Let's say you were stopped and you have a suite of charges. So let's say you were initially stopped for maybe, I don't know, driving without your lights on, but then they happen to smell marijuana. They do a search. Now they found that you're in possession. I should say that the opposite way, actually. Someone smelled marijuana. They stopped you. They ran your license. They now see that, like, you have points or something, but the resulting charge was based on that predication of we smelled marijuana, so that's why we stopped you. What happens to that latent charge? Does anything happen? Because had they not used that marijuana smell to stop you and then run your license, they would have never known that you were driving with a suspended license or whatever secondary charge happened. Will any of that be taken into account when we talk about charges, or not so much?
No. So pretextual stops will still definitely be a thing.
Okay, great. Good to know.
Okay. And then, you won't, obviously, in your situation, that person...
Well, not mine, just hypothetical situation.
Yes.
No,
In this hypothetical. I wish that on nobody.
Generally you.
Right.
Correct. In addition to the driving without a suspended license, you're probably looking at, driving under the influence.
Okay.
And even when marijuana becomes legal, that is absolutely something that they plan on enforcing. So you should not be burning cannabis actively and driving. Okay. I will say that there is a issue of sort of, and like this is still an open question of being able to determine whether or not someone is actively under the influence versus just like, I consumed cannabis, 2 or 3 days before, just because it's not going to stay in my body. But we assume they'll still be conducting, normal field sobriety tests, and if there are signs of impairment, you absolutely still will be receiving, DWIs and your license suspension. The only thing that would happen as a result of this new law would be your marijuana conviction itself goes away. Everything else, you are still going to probably be paying fines and are going to jail for.
Would that be a viable legal argument, though?
What's that?
Like, we should not even be discussing this because I wouldn't have been, you would not have been aware of my circumstances if not for this trumped up, Is that a legal sound, or no, not really? That's not a sound legal argument.
To me, just about every argument is a sound legal argument.
I like
so, I don't make a habit of saying things that will get me laughed at in court, but there are arguments that's where the plea bargaining comes in. So a lot of people are under the impression that when you appear in court on a charge, you're really dealing directly with the judge. That's not true. You're dealing with the district attorney before you even go to see the judge, and you're plea bargaining. You're telling them why your client deserves a better deal, why they shouldn't have to pay this fine, why they should be offered a plea for this charge as opposed to that charge. And like I mentioned, often the district attorney wants you to plead to the top charge, whatever that might be on your docket. So let's say you are stopped for speeding. That's a violation under the VTL, the Vehicle and Traffic Law. The police officer approaches you, tells you to put down your window, looks at your license, smells cannabis. Maybe he goes back and runs your license and sees that your license is suspended. So now you're looking at a speeding violation, which is not that big a deal. The 511 VTL charge of driving with a suspended license, which is a misdemeanor, and the violation of possession of cannabis if they search the car and find it. Often that case would just end with a plea bargain to one of those charges. It might be the traffic infraction, a reduced suspended license charge, which would just be an infraction and a fine, no criminal record at all. Or they could have you plead to the violation. Just up to now, I never had my clients plead to marijuana violations. I always wanted them to get a disorderly conduct violation because at the end of the day, it looks better to have a disorderly conduct than a drug charge, depending on who's looking at it. With other charges, again, plea bargaining is very important. I did have one young man, he was about 18 years old, and he had 5 open cases. They were all inclusive of a marijuana charge, but then there was a resisting arrest, or there was loitering, or some other charges. One of them was an assault, but they all had a marijuana charge on them. In anticipation that the law around cannabis would change, the district attorney wanted to resolve the cases with a package deal. He had to take one misdemeanor, and then the others would be disorderly conduct. So I said, as long as he can take a B misdemeanor for marijuana, we'll accept that plea deal. So he has one charge on his record right now that's going to be expunged in the next, year or so.
Wow.
So it kind of all comes down to plea bargaining. These cases do not go to trial. 90% of cases in New York City, no matter what the charge is, don't go to trial. It often comes down to plea bargaining. And especially with misdemeanor cases, oftentimes they'll reduce the charge that they want you to plead to as long as you pay a fine or do a program or do some community service. So you really can work that out, however many charges you have, because you might get a suspended license, a reckless driving, an endangerment, something like that. Now, the DUI charges, driving under the influence, those are a whole different animal. Even if you don't have the cannabis in your possession, you can get charged with 1192-1, which is driving impaired, or 1192-4, which is driving under the influence of alcohol and or drugs. And then you have to deal with those consequences. But it really just comes down to plea bargaining.
So a question about that driving under the influence. There was a state, I can't recall, that tried to do some testing, but it were found inconclusive. Is there actually a test that can be given to drivers now in New York State and New York City to, what does that mean when they say driving under the influence? How do they determine that? Is the threshold only a smell, or what do we think this will look like? And is it currently happening is part one to the question. And if not, what do we think this would look like in the future? Did everyone hear me, by the way? Okay.
Everyone understand the question? Okay, so it's kind of that the officer goes by circumstantial evidence. When they stop someone, depending on whether there was an accident, if it's a traffic stop, or if there was some type of erratic driving, there's statutory language of the signs that they're supposed to look for, whether you are unsteady on your feet, whether you have bloodshot, watery eyes, slurred speech, a smell of either alcohol or marijuana on your breath and around your clothes, if there is possession of marijuana in the car, things like that. The sobriety tests, field sobriety tests, where they ask you to touch your nose and walk in a straight line, things like that. There's no test for active impairment. You could admit to having smoked an hour ago, 2 hours ago, a day ago. It's going to come up in your system when they give you a chemical test, but that's not going to mean you're actively under the influence. Yeah. So it's kind of just circumstantial. And it's not until the it's really not until cannabis becomes legalized that they'll really study that and be able to develop the machinery to detect active impairment. That's my personal belief.
Shatad, do you believe, like, what do you believe the process would look like? Or do you think that there will be an office that will kind of create a process for this now? Like, we don't have how to determine someone's under the influence, but now that we're seeing legalization happening, we should think of a process, and if so, what do you think that would look like?
So if marijuana does become legal, the
Yes.
state will absolutely make investments into research to either train officers to recognize the signs of impairment for cannabis,
Okay.
and then and probably in the long term to be able to develop that kind of technology. What that looks like, I'm not sure, but I know when they were looking at the sort of finances related to legalization, there was definitely a line item for research and education. So that will absolutely be a consideration. And for no matter what state which has already legalized cannabis, all of them still actively prosecute driving under the influence. So
So another
get a
question.
lift.
Call
it.
If you're under the influence of anything, just get a lift.
So what do you think, or what will be the process now as far as police officers are concerned when it comes to cannabis? Are they going, what does the process look like? I'm a police officer, I'm walking down the street, and I think I smell some cannabis. What would be what is the protocol that they're being taught now with decriminalization? Is there a switch or a change in protocol now that it's decriminalized?
So I mean, the city did update the NYPD patrol guides.
Okay. And this was when?
Like literally on August 28th when the law went into effect. But I would say that for the most part, and I don't want to broadly generalize, aside from the ceiling aspect, day to day for New Yorkers, I don't think you're going to see a big difference in between this new decriminalization sort of process versus what it was before. Because the city had already begun issuing violations already for cannabis possession. And so when we began that last summer, there was already an 81% drop in the number of arrests. I think that that's going to probably continue to go down. And the main reason why even individuals are being arrested was really because for the B misdemeanor charge for like the open in public definition, which has now been removed by the new law. If an officer patted you down and then pulled out the cannabis, now it's now an open in public view.
Take it out yourself.
Correct. It's now in public view. So like that, because they've removed that, by and large, everybody's just going to be given a violation. I won't say that you can't be arrested under any circumstances. Obviously, you have to have identification. Somebody could begin trying to resist arrest or anything along those lines. Obstruction, like if they wanted to, bother or depending on the individual who was being talked to, all of those things will matter. But as far as NYPD's main role, they're just going to be giving you a ticket and you're going to go about your day. I would also say that I would be shocked if officers began spending a lot of time on cannabis just because they already are aware that you're just going to pay a fine and it's going to be automatically sealed. It seems like a lot more trouble than what it's worth, if we're being completely honest.
Okay.
So if I could just piggyback on that, I agree with everything you said. The day-to-day for New Yorkers for cannabis possession, I don't see it changing very much because, like I said, the violation is still an arrestable offense. They can still arrest you, and as opposed to you getting a pink ticket and telling you to go down to, Borough Hall and pay it, you could be arrested, and that's more likely going to end with an ACD, or paying a fine to the court, and adding on court costs for your plea there. The issue is the law being what it is, the enforcement is still what it is. So we know that, the arrests, 90% or more are Black and Hispanic males. The summonses issued, 87% are Black and Hispanic males. So even though since cannabis was decriminalized again, in 2016, I believe Mayor Bloomberg decriminalized again, even though it's been decriminalized since the 70s, there has been a rise in summonses given, and I just, made a note of the numbers by quarter. In the fourth quarter of 2018, there were 3,372 total summonses given. 88% of those were Black and Hispanic. In the first quarter of this year, 3,790 total summonses given. So that is a rise in summonses. 87% were given to Black or Hispanics. The second quarter of 2019, 3,969 total summonses given. Again, a rise in the summonses given out. 89% Black and Hispanic. Whereas you have arrests, which in the fourth quarter of 2018, there were 520 total marijuana arrests with no other charge. So that does not mean people arrested on several other charges that we talked about. But 90% of those arrests were of Black and Hispanics. In the first quarter of 2019, there were 606 total marijuana arrests. 92% were Black and Hispanic. And in the second quarter of this year, there were 455 total arrests. So the number did come down. However, 94% were of Black and Hispanic citizens. So the fact that the law changes and evolves is one thing, but the enforcement of the law by the NYPD is something that needs to be looked into, because obviously we as Black and Hispanics are no more likely to be using cannabis, especially not out in the open where it's often, found and arrested or found and the law enforced. But why are we getting the highest number of arrests and summonses for something that everybody is doing? It's very hard to walk down the street in New York City and not walk through a cloud. So somebody's around doing it. And you may see a face and it may not look like yours, but the face that gets arrested or issued a ticket is more often, overwhelmingly, Black and Hispanic.
So,
I want to piggyback off of that, though. So, agree fully with the numbers and obviously the statistics regarding the racial disparities. But I will say that we're going to probably see a bigger one. If you heard her numbers, there were significant drops going down from thousands to hundreds. Last summer, when we began the process, there were still several exceptions for when a person would just be issued like a ticket and leave. And that was whether or not you had past charges related to cannabis, whether or not you were on probation. So obviously sort of rooted in that was you generally probably were either on probation or had past charges, primarily because of sort of the predatory practices and disparate enforcement against communities of color. But as we sort of move forward, because those things will no longer be exceptions for when NYPD could give you a violation versus when they could arrest. I think we'll see even greater, far steeper declines in the number of arrests moving forward. Because now they will.
Just one moment. We don't. Let me go. Right. Okay, sorry.
But yeah, because those exceptions have gone away, I think we're going to still see significant drops.
Okay. So my question for you both is, are there any assurances, or are there any key phrases or trigger phrases we should know if we feel like a police officer is not following protocol? I'm not smoking in public. Maybe we were stopped because we were rowdy. I don't know. We were searched. It was less than 25 grams, but I'm getting taken down. What happens then? Because I shouldn't be, right? There should be some kind of ticketing. I should be getting my pink slip, but I'm in handcuffs now. What should happen? What should I say?
Nothing.
Okay.
That is your honest to God answer.
Okay.
Save that for court.
Okay.
Do not try to make court on the side of the street.
Okay.
Don't become a superhero.
Okay.
Call an attorney and be quiet and get your ass in the car.
Okay. All right.
Absolutely.
Okay.
Because violations are still arrestable offenses. If the police officer wants to arrest you, they absolutely will. And you getting loud and rowdy is not going to make him say, "Oh, you know what? You have a point. Let me take these handcuffs off. Are you a little more comfortable now? Okay. You know what? Just walk away." No, it's not going to happen. So we all know what happens when arrests go south, left, wrong. You're not going to talk an officer out of an arrest, so stay as calm as possible. If you are arrested, you just make no statements. Either they saw what they saw or they didn't. Either they're accusing of what you did or you didn't do. You save it for court. And again, plea bargaining, it can go a long way. If you make it known to the attorney that you have or the attorney that you are assigned what your situation is, you can walk away with that in a much better position than if you try to make war with an officer on the side of the road.
Yeah, don't go picking up a new charge because you want to get rid of this.
Right,
Okay.
resisting arrest, disorderly conduct is a violation, but obstructing governmental administration, they love that one. Obstructing governmental administration, resisting arrest, and disorderly conduct. When I see those charges on a criminal complaint, I just know that person got mouthy and the arrest went left, because that's all that means.
Okay. So let's say you have your criminal record, you have one or multiple charges, they've been sealed and will eventually be expunged in this new bill. What kind of employment opportunities are now accessible to me that maybe wouldn't have been? Like, can I be a police officer? Can I be a security guard? Can I be someone who holds a firearm? Because now my record is technically expunged or not? Did you guys understand that question? Okay.
What I would say to that is, before you apply for those things, make sure you get your certificates of disposition. So even if you don't have your full rap sheet, or if you do have a full rap sheet, you can get a certificate of disposition for each case that you have had. You can go down to the clerk's office of the court where it took place and ask for a certificate of disposition. There should be an indication, if it is for a cannabis charge that is now going to be expunged at some point, that it has been sealed, will be expunged, whatever the case may be. Also, if you have other charges on your criminal record, you can get what's called a certificate of relief from disabilities. That you apply to the judge and say, Judge, I had these charges back whenever, and they're preventing me from getting employment that I want. You apply it to the judge, and they pretty much grant it as long as you're not. I think as soon as you finish your obligation. So if there was any jail time associated with it, if there's any probation or parole time, not parole, but if there's any probation time, there is still relief from disabilities. People are not supposed to use past convictions against you.
Shita, can you speak to the kind of employment opportunities? Can you hold a firearm? Can you be a security guard, a bank?
Just know that government agencies, if you're applying for a government agency, they can pretty much see everything.
Even under this new bill that will technically expunge, they'll still be able to see?
So as far as right now, yes,
Okay.
up until 2020, people can still see.
Okay.
As far as the hiring, I think that's probably a bigger open question. I think generally speaking, I know when legalization was on the table, law enforcement actively wanted to still have access to the records to be able to make judgment calls related to hiring for all layers of law enforcement.
Okay.
As far as possession of a firearm, in terms of like being either a peace officer or just general possession of a firearm, you weren't inherently excluded, to my knowledge, just because you had a drug charge automatically. Not for marijuana, I don't believe.
I don't think so.
Yeah, I'm not aware of any like automatic exclusion from like possession of a firearm. I would say that law enforcement to become a peace officer probably was going to prevent you from becoming a peace officer related to past drug charges. But as an individual person wanting to own a gun, no. As far as being in New York City, you probably weren't going to get access to a firearm anyway. So I don't really see this as a real issue.
Okay.
I've seen the New York City firearm carry permit application. You're not just gonna get a firearm. It's not gonna happen. It's about 50 pages. They want to know everything, if you've ever even been arrested, any kind of police contact that you've had, how it turned out, certificates of disposition for everything, why you want this firearm, where you want to keep it, what you want to do with it. You have to pay for it and then pay separately for the application and the fingerprinting. Take it down to 1 pp yourself. They can deny it for whatever reason. They may never even give you a reason. So it's such a long and arduous process that's not just something you do on a weekend. As far as getting a job that requires you to carry a firearm, either security or with the NYPD or even the FDNY, their hiring could be completely discretionary when those kind of things come up. And you may never know what the actual criteria for them hiring or declining your application would be. You may just never know if that's why they declined you. So once these convictions are sealed and or expunged, you can try to apply, and
Hope for the best.
good luck. Yeah.
Okay.
I will say for general employment, you don't need to list that you have a previous arrest for marijuana
They're
offenses
not
or
supposed to
anything along
ask.
those lines.
Okay.
Yeah, so you can treat it as if if it had never occurred to you. So for other sort of opportunities, other professional licenses, you're generally going to be good to go.
Okay. Now, when it comes to the actual application of the bill, so 2020, do you have any recommendations specifically for communities of color as far as making sure or ensuring that this process is beneficial to them? Is it worth doing that inquiry to get your record, or is it better to just kind of fly under the radar, wait for a system to be set in place, and hope that your record is attended to? Or do you suggest we be actively pursuing our criminal records and making sure that we are in control of this process once there is a process?
So I would first say that we should probably wait and see how the process plays out, and then sort of go from there. Like once law enforcement agencies, once DCJS has sort of figured out like how this is going to function, wait like a month or so that way you can then maybe inquire on your own if it's something. I feel like for many people, there would never be, unless you're seeking an opportunity specifically where you know that you're going to have a background check run on you. Maybe at that point or prior to that point is when I would probably go to verify. You shouldn't have to do anything, and I won't say that communities of color will need to be situated any differently than like a white person would be in relation to it, because it is automatic and is applying to all offenses for everyone. So by and large, you should just be good to go. I would say, particularly like a community like Brooklyn, I wouldn't advocate for everyone to just sort of automatically go request their records, just because they still have so many individuals here are immigrants, and I would hate to see in your zealousness that you end up getting pinged for ICE related to something that would not have been on their radar just because of your zealousness. So like that's sort of the double-edged sword.
And adding on to that, I deal with people with varying degrees of criminal histories. And a lot of times, the process goes so fast when you're in court and you get in front of a judge and you're nervous. You may not hear everything, except you hear it's like stay out of trouble and it'll get dismissed and sealed. Or if you just admit to this or that, you get time served. And people walk away maybe not even knowing what just happened. They just know that they're walking free and they don't have to come back, and they may have to pay a fine and they may not. So I wouldn't, just as was said, I wouldn't say everybody just run out and go get your criminal record. It affects some people more than others. If you know you have past convictions, sometimes I'll speak to a client and I'll say, okay, I see that these things are coming up on your rap sheet. Oh no, they threw that out. No, actually you pled guilty to it and you have it on your criminal record. It wasn't a violation, it was a crime. They go, oh really? Like they did not know. So for people who are seeking an opportunity that a background check would be run. I know that in New York now they're blocking the box, so you're not supposed to be asked if you have a criminal record. You're not supposed to be hired or declined employment based upon that. Even before that, I think they only really asked if you were convicted of felonies. But any way you see that question, it's wrong to ask. But if you know that a background check is going to be run and you are fearful of what that might show, I would say first contact the office of the attorneys that you may have last dealt with if you have had criminal contact. Like if you have been arrested in Brooklyn or have had to go to court in Brooklyn, call Brooklyn Legal Aid and say, I'm a previous client. I just wanted to speak to the lawyer that I dealt with. Even if you don't remember the lawyer's name, for some reason nobody ever remembers their lawyer's name, and we're the only person.
Such a, high pressure. Like you said, it's kind of traumatic. Like I said, I'm kind of familiar with the system, so it's like the last thing you want to do is think about your time in a courtroom.
Yeah.
You want to. You want to block it out. You want to repress it.
Yeah, and sometimes you may get
a
different attorney from one appearance to the next, depending on how many times you have come to court. But they always have your records still there. You can ask them. You can tell them your name and your birthday. They can run and find out what your last contact with their organization was. Put you on the phone with that lawyer. Pull your file from the archives and tell you what's on your rap sheet. Doing it this way again is gonna. If you request it directly from the Office of Criminal Justice Services is going to be a fee, $63, $64, and wait time and fingerprinting that might put you in danger of getting, flagged for something or another. So, yeah, I would say go to the legal aid office first and see if they can help you.
Okay. This is my last question. If you guys have any questions, feel free to ask. But I'd like both of you all to play devil's advocate for a little bit. And
Devil needs no advocates.
and if you can, if you can think of any kind of adverse reactions or any kind of collateral damage that could possibly happen with the inaction of this decriminalization and this new bill and this expungement bill, do you foresee any kind of issues that we might not have given any thought to, or any kind of residual damage aside from, opening yourself up to kind of any ICE issues if you are an immigrant? Are there any other foreseeable things that we should just keep in mind, put a pin in, that it may be something because maybe it wasn't included in the language, maybe it's not actually, concrete in the bill, but you can see how it could be applicable? Are there any kind of instances where you think this new bill can create some kind of complication? The answer could be no, too.
One thing I would just say, as far as our own responsibility or your responsibility as consumers, even if it is legalized, it's been decriminalized, perhaps on the way to legalization, employers have discretion. They can still drug test you, and they may still be able to, say that they don't want people that use any kind of drugs, cannabis included, working for their organization. So you may still be discriminated against. This is not the time to go yelling through the streets, weed is legal. I smoke weed, it's fine. No, it's your discretion is very important because other people that you come in contact with have discretion. Officers have discretion to still arrest you. Employers have discretion to still deny you employment. And I see there being changes, but we still have to be responsible and diligent citizens.
Piggybacking off of that, so one, and I can't remember the effective date of this, but there is a local law that passed maybe a couple of months ago. So moving forward, at some point in 2020, most employers, not all employers, will be prohibited from marijuana drug testing. That, and I can circle back if folks want to know the local law number and the effective date on that one. But there are plenty of exceptions to that, like obviously anybody in
Machinery.
Yeah, but also anything dealing with the federal government, and that can also include oversight. So like hospitals and things of that nature, like those places will still obviously need to continue to drug test.
Okay.
But for the most part, I can't think of that many sort of collateral consequences as a result of an automatic sealing or expungement. I think that this part is pretty positive, and as we think about getting to a point where we actually have full legalization, it's actually better for people's records to automatically already be sealed. So that way, if you're trying to secure financing or anything along those lines, you're already a little bit better positioned than you would have been if that hadn't been in place. The only thing that I could think of that could maybe be a point of contention, and this is like super technical, so I don't want to talk over people's heads, but they amended the public health law definition for like marijuana for smoking under 3302, but the 221 for marijuana generally refer to just the plant and not necessarily to like the extracts for everything else under the public health law. I mean, I think it's an open question, but I don't think that anybody's going to be out here trying to get you for if you're smoking THC pens or like resins or shatters or anything along those lines. But like for the most part, I feel like it's covered under the 3302 smoking definition. But that's the only sort of thing, and that's kind of small.
Okay.
Well, we have been talking about weight for the most part of, probably dry herb flower. But the 221 section does have language that says compounds, mixtures, things like that with an aggregate weight of. So they do arrest people for having marijuana THC cartridges. vape pens, things like that. And while it is a little bit difficult to prosecute those because of the lab testing requirement to go to trial, often they end in plea bargains, ACDs, disorderly conducts, things like that. But the language was amended from burning or open to public view. That was taken out, and smoking was added to the public health law. So it does say that, well, what the meaning of that is that smoking cannabis would be prohibited anywhere smoking tobacco would be prohibited. At the same time, you can't smoke something without possessing it. So there's no charge, for smoking marijuana. The charge is possession of marijuana. So however you possess it. I do work in Queens, so I see a lot of airport cases where large amounts of drugs, large amounts of different compounds, whether they be edibles, whether they be cartridges, things like that, come through. I don't often see arrests for small quantities. Like, I don't often see someone came through the airport with a marijuana cigarette or with a small amount of marijuana. I don't often see that. Usually what I see is felony level weights of, I saw one guy, he had like cases and cases of gummies, and he also had pills. So really, they weren't even
Marijuana
looking
pills?
to. No.
Oh,
I'm sorry.
guys.
Other
I was like, marijuana
narcotics.
pills? Like,
He had
what is this?
ecstasy pills. He had MDMA.
Right.
Yeah, so it wasn't even the gummies, or it wasn't even the edibles that was the bigger issue. His issue was like the 2,000 ecstasy pills that he was carrying, and the cannabis.
Right. He's trying to flood Manhattan.
Yeah. Yeah. But again, it's just on us to be responsible and use discretion.
Okay. I know I said that was my last question. It wasn't. Does anyone have a question before? Okay, in the back.
But what about the people, we've been talking about misdemeanors and lower level offenses, but what about the people who are serving terms of probation, and the law says you can't be around drugs? As this becomes more and more legalized, what do you think are the impacts on those people who are serving long terms of probation or even lifetime probation?
Don't do it. So
But you're just exposed to it in the community.
Yes, but they've always had a responsibility to abide by the laws of probation, not only the penal law. So I recently spoke at an orientation for newly released offenders, people who have been released on either probation or parole, and we spoke about all the different things they had to take into account. And one of them came up. Cannabis is being decriminalized and possibly legalized. Other states, it's fine. Probation can still violate you for possession, for dirty urine tests, for dirty saliva tests. They can still decide what their rules are. So we basically advised the clients, just don't get caught up in it. Don't do it. You're exposed to it in the community. I don't know the level of exposure you have to have. Just like I said, you can walk through a cloud in New York City and know that somebody is smoking cannabis around. I don't know that would end up affecting the level that's in your body from just inhaling secondhand. I don't imagine it's very high, but there's a clear indication if you're tested and cannabis comes up in your blood or in your urine. There's a clear indication that you've consumed it yourself. So I would just say probation can inform them on what the rules are, and cannabis will just not be, included as an okay thing. Even medical marijuana. I do not, again, we were at an orientation speaking to, the newly released offenders, and the speakers from the probation office said, no, we're not going to allow you to have medical marijuana. Like, there are other pain relievers. There are other things that you'll be able to deal with. Going forward, probation may relax, but I don't see that happening.
So my question then would be for you, is there any plan on a statewide level to change that? Because for the laws to be changing to benefit just the general public and not to change to benefit individuals who have been arrested for marijuana possession in the past would be wrong. Is there any plan address that.
Is there any social equity discussions being had at all? Because, I mean, if we're going to be talking about how disproportionately all of these war on drugs laws have been affecting people of color and how the people that are primarily being affected and on probation, you know, I mean, are people of color, for them to not have access to these things and then everybody else to be benefiting from it seems a little bit unfair.
So I would say the answer is yes to both of those questions. So in relation to like parole, the Less is More Act is a bill that sort of sought to, and that one's with Benjamin and Mosley, Senator Benjamin and Walter Mosley in the Assembly. That bill sought to sort of remove the ability for the department, for parole, to be able to violate someone related to marijuana-related offenses, as well as a host of other reforms for broad parole reform. So that is a part of the discussion. And then certainly with respect to the actual legalization bill, equity has been sort of a part of the conversation, and making a dedicated funding stream, ensuring that you actually have equity and licensing opportunities for communities of color that have been impacted by obviously the war on drugs, and providing like funding and grants to those areas, sort of like what that looks like, how it shapes up, number of licenses. All those are still open questions. The Mayor's Office of Criminal Justice released our report. It's something that this administration believes in fully, and wants to create equity and licensing opportunities for not just black and brown communities, but primarily black and brown communities who have been impacted by the criminal justice system. So that is going to be ongoing. You know, I'm a little skeptical just in relation to everything that has been happening around vaping. And I know, obviously, the flavored cigarettes got banned, despite the fact that none of these illnesses have been actually happening from flavored cigarettes. And it's actually all been, you know, black market THC vape pens and those thickeners. But I could easily see that sort of derailing conversations as we move towards legalization, even though the smart thing to do would be actually to legalize them, because you need to actually, correct. Because like if you create avenues for people to buy legal products, they're not going to go and buy it from the corner boy around their way. Make sure you know where you're getting your stuff from and be safe. And I would say that the Department of Probation, New York City Department of Probation, not parole. So one, everybody's going to abide by the judge's orders for whatever is given, and that's not up to our discretion. But generally speaking, New York City Department of Probation does not like violate individuals for marijuana, and there was a recent local law passed that also stated that as well. So
Just program.
correct, yeah, it's like mostly programming. They're not gonna, no one's looking to throw somebody in jail just because they smoked a little bit of weed in the New York City Department of Probation.
Is it the same for fraternizing? Because I'm not really familiar with probation or parole agreements, but it's like you can't be, you know,
Fraternizing with somebody
your
with a
cohorts
past
can't be a
record.
felon. So this supposed felon that we're talking about had a felony marijuana charge. Like, does that still apply? Like, I can't say my uncle because he has a felony charge if I'm on parole right now.
I mean, right now, if you're on parole, that could still be one of your conditions of parole. The Less is More bill that I had mentioned earlier is one that seeks to sort of change that aspect. But as of right now, yes.
Okay, but hopefully to be determined, as in this will be something that will be ironed out.
Hopefully so.
Okay. Anyone else has any questions before my final question?
One.
Okay,
two.
two.
I'm sorry. The local law that prevents the testing of the parole, is that the same as
Probation, not parole.
probation? Is that the same as the local law that allows employees not to test you, or?
There were two different local laws.
Yeah, what is the legal limit for concentrates? The actual number.
Yeah, they didn't.
It's like significantly more than flour, from what I recollect.
When you say concentrate, you mean
Oils,
possession of?
tinctures.
They're all looped in the same language. So compounds, mixtures, all the aggregate weight would still have to be
25
those.
milligrams.
Yeah.
Or 20.
Well, they've changed the 25 grams to 1 ounce. So the violation level.
That's a lot.
That's correct.
Like if we're talking about fluid ounces,
It's 25 minutes.
like that's a
How big is the
Violation.
tincture? What does that feel like? Like, how
tinctures come in like little, very small bottles. So if we're talking about,
This is
But I think-
1/16 of this bottle is 1/17 of this bottle is 1 fluid ounce.
See, I think that's the issue.
we're talking about
Yeah,
25.
there was
So that's a lot.
really like you got the like.
Yeah.
You can't
I'm not a math person. I came to that conversion.
That's more than
Okay.
Yeah.
So we're not sure. 25.
Under the penal law 221 sections, it's 1 ounce.
Okay.
It-
I have one. Sorry.
No, go for it.
My.
Oh.
You can finish that thought. I didn't.
Oh no, just the way that it is written in the language would be compounds, mixtures, with an aggregate weight of whatever the level is for that particular offense.
And then my other question is, do you guys? This is kind of a personal question, but have you had any engagement with people that have been recently released? You were talking about like these training seminars that you're doing. Can you expand upon that and explain what resources are available to people who are coming out of incarcerated situations and
Specifically related to.
cannabis-related crime?
So the Office of Probation on Jamaica Avenue in Queens, it's off Jamaica Avenue, but Merrick Boulevard, they do an orientation every Friday, last Friday of the month for whoever had been released up to that point. And during that orientation, they give a wealth of resources for just general good law-abiding citizenry, right, if that's a word. For cannabis specifically, there weren't many resources targeted toward cannabis specifically. Obviously, it's like don't smoke it, don't be in possession of it, don't get caught with it, don't give us any reason to put you in a program. They do have programs, though. That being said, if you come to your probation officer and either you test positive for cannabis or any other type of narcotic or controlled substance, they'll put you in a program. Or if you tell them, listen, I think I need something. I think I need maybe an AA or an NA program, something like that. They will facilitate that.
I was talking more on the lines of, sorry, I didn't mean to cut you off. I was talking more along the lines of professional development and more of like practical engagement on like reintegrating into the workforce and other professional outlets like that.
So, I mean, I guess the hard part is the reality for the offenses that we're talking about for like decriminalization, more often than not, individuals weren't going to prison or to jail for those offenses to need reentry programs. Like they were being arrested, but then they were basically getting ROR'd and going back into the community. So like maybe they've been doing like programs for like that short-term period, but like no one was spending years in jail just for like possessing an ounce and a half.
What about
Yeah.
Yeah, because I was
But
gonna
now
say,
so now that's but like
I'm
at
talking
that
about
point.
any cannabis
yeah, like let's say there's someone.
Oh, so you're talking about felony level?
Yeah, someone transported from Albany. They drove down to New York. Someone stopped them in their trunk. They had like 3, 4, 5 pounds. They've been in jail 3 years. They just came out.
But I mean, they would
That's a
be.
federal crime as well because you're crossing borders.
Yeah.
I've tried a marijuana case where my client was driving around Far Rockaway with 4 pounds of marijuana in the car. From the beginning, from the plea bargain stage, they said, listen, if he'll take a conviction to a misdemeanor, we'll give him time served or something like that. So they're really not, in New York, perhaps in Queens, they're not trying to put people in jail for years for marijuana alone. Like I said, the guy with the pills, completely different story. Controlled substances are a completely different part of the penal law than the marijuana codes. So my client was adamant that he was not pleading guilty to anything. We went all the way to trial, and he was offered, he had already done a couple of months because he couldn't make bail, which is another issue, the bail reform. But he did get convicted, and the judge gave him like 7 months, which was basically time served because he'd already served a good amount of that. And the judge even offered him 5 months on the eve of trial, just because what are we all doing here, right? And because he was indicted on the felony, he had to take the felony charge or risk, either blowing trial or not. But at the end of the day, the sentence was not, some draconian sentence. Now, when you're talking about bringing it across state lines, you're talking about a federal issue, which the federal law still is what it is. It's illegal everywhere under federal law. Trafficking, you're talking about not just possession, but trafficking, distribution, intent to sell, things like that. That brings a whole host of other penalties, which, that doesn't, nothing that the new decriminalization law says addresses that. Those laws are still very much the same.
And then, I mean, in general, obviously, like New York City has a sort of an array of reentry services programs. None of them are like charge-specific reentry service programs. So it's like there are opportunities, like we have jails to jobs available to people who are leaving Rikers Island, which generally speaking wouldn't be the situation related to a cannabis-related offense. But for other individuals.
Rikers for cannabis-related felonies, though, aren't there?
No, they're not.
Is more than a year in jail, whereas you don't serve the time in Rikers unless it's a city year.
Correct. Yeah, so like, while people may anecdotally say that there are a bunch of people who are in on Rikers, the reality is, I feel like when we ran numbers, there's probably not even 100 people who have, like, between sex offenses, between drug-related, not like, speaking of marijuana-related offenses. Yeah, like these like sort of like lower level offenses. That is not the Rikers population, like at all. But if somebody were to be leaving Rikers Island, they're available to get reentry services through jails to jobs programs. Our office contracts out with a lot of the providers doing reentry, and none of those things are like charge specific. I mean, if you have like a more particular question, I'm happy to follow up with you.
I have questions, so I'll save them for individual circumstances. But one last one, percentage of women who are being charged, whether on whatever caliber, right? We're talking felony, misdemeanor, or on just the violation. What is the demographic between like the percentage of women that are incarcerated?
I just want to say this is the first time in like our speaker history that like our speakers come with like no cards and statistics, and I think you create a new threshold. I'm gonna be like, you guys need to come with your own data, okay? Right? We need to cite these sources, okay?
So in 2018, this is statewide, there were about 10,000 arrests for marijuana offenses under 221. Speaking of both of those charges, of that, 93% of those were men, 7% of those were females. Yeah, so it's pretty much, and that's like 60% were black, 32% were Latinx, 4% were white, 3% other.
Do they break down the race or ethnicities for the genders? Like how many minority women, how many minorities? I wouldn't want to know what that looks like.
I mean, it's 7% female, so I can tell you it's going to be
6%
literally
black and brown.
Yeah,
Yeah, about 8.5%.
Okay.
I did write down just if you wanted to go. Obviously, you can Google these stats on the New York City nyc.gov/site.
Oh my
God. So the NYPD has to keep these statistics, right? And they do break them down by precinct, by borough, and then by gender, race, age, but not gender and race, So you kind of have to just
infer.
Yeah, you kind of have to infer that 7% are women, but if 97% of the arrests are people of color, then out of that 7%, perhaps 97 or a comparable number are going to be women of color. It is very low compared to Black and Hispanic males.
Any other questions? Okay, so my last question is, post this meeting, July, is it 29, 2020, or is it June 29, 2020? July 29, 2020 comes. Are you recommending that people have their physical copies destroyed? Is that a step that needs to be taken? Is that something that people should spend time on, or does it make any sense to get your physical copies of your criminal records destroyed? That's just my last question.
I think it depends on the person.
Okay.
But it will absolutely depend on the person. But day to day, no, you'd be wasting your time and paying the fees. Like just to be real with you.
So you get arrested with a group, and your record is sealed.
Depending on what your clear.
Definitely for marijuana. I'm personal. This is personal experience. So I got arrested with a group of people. So it was what is it, a sweep. I went to go and get my records just to check it to make sure that it was sealed, and was told that I couldn't even get it because it was with the group, and so that would be a violation of their privacy for them to provide that to me. So I have to actually hire an attorney. So my question with all of that information is, when we're talking about the automatic expungement, would my record, along with the records of the other individuals that were picked up in that sweep, be automatically expunged? Or because we were picked up in a sweep, is there still a motion that would have to go through?
Assuming that all of the individuals were
hope so.
only charged with
Right.
one of those 221 offenses that are
Yeah.
now decriminalized,
Yeah.
then no.
But
But
in the
I
event
would need to
Someone
know,
else in that group was picked up for something else
then that's just on them.
Yeah,
Oh,
you might not all be docketed together. You have to all have
the same.
You have to all have the same charges to be on one docket,
Oh.
under one docket number. Just trying to think of the best way to answer your question so that it makes sense. Who told you that you couldn't get your particular?
I went to 1PP.
Oh no, don't go to them for
I-
anything. No.
First, wait. I went downtown Brooklyn, right?
To the court.
Right. I got a copy of my paperwork.
Yes.
Of the charge, and then I went to 1PP because I wanted to make sure that it was sealed.
Did you get a certificate of disposition? That's what you got from the court?
Yes.
Okay. Going down to 1PP. So, no, the sealing, I think I wrote a note on the sealing process. It's in that super long website address that I mentioned, but that's more of a petition that you have to put in, not actually showing up. You know, that's more of a petition process that you have to fill out an application.
But it's still.
But I think I think you have a nuanced situation, if I'm not mistaken. So I believe what your issue was is you got your record sealed from the courts for
After the, right, with the
correct.
ACD.
And then you attempted to go to NYPD to inquire whether or not their internal records showed your thing is sealed.
So it was research for me because last year, DA Gonzalez had where you can come to Brooklyn to the hospital and
More
check and
forgiveness.
see
Yeah.
whether or not you had record, and if you did, they would make sure that everything that it was dealt with, that it was sealed. So when I went there, I asked for my information, and I was told, no, you have nothing, you're fine, you're not even in the system. That was weird, because I know that I was in the system. So I then went downtown to Skimmerhorn, to the courts, and I requested my certificate of disposition. I was given that. But because I was told by the DA's office that I was not in the system, I needed to know what they were looking at that showed me not in the system versus what someone else was looking at that showed me in the system. So I got my certificate of disposition, and then I went to 1PP.
So one, the systems aren't necessarily the same. So but they won't be, but because
Why is that, and what is the
So in the sense that if you were to run a DCJS background check on someone who has their record sealed, they won't transmit that information to the public about that record being sealed, but law enforcement entities can see even all of those sealed records. So just because it was sealed,
the district attorney's office, not law enforcement, and so why would they not be able to see the
so I mean, I can't opine on like what they relayed and how they related, but maybe they meant it in the sense of like, for your purposes in relation to employment aspects and the broader world, you don't have anything in their system, but that still didn't mean that they don't have your own individual rap sheet showing those records. Because like NYPD would still be able to be aware that, hey, this person has previously been arrested on this offense, or maybe they had a sealing, but they still get to see that from like an investigatory standpoint. And that part, I mean, up until this new law takes effect, that still will kind of be the case.
So the website I gave at the beginning of this session, the criminaljustice.ny.gov site, when you request your personal record, I'll give it to you after. When you request your personal record, you could get a suppressed record, which means it does not contain the sealed cases, or you can get an unsuppressed record. The unsuppressed record has even times when you were detained and they declined to prosecute. Those cases that were closed before they went anywhere, cases that got ACD'd and sealed, cases where you pled to disorderly conduct, and after the conditional discharge period, that was sealed. Cases where you took a plea to time served, and that was sealed. So the systems are not the same. Even if the court has your records as dismissed and sealed, the NYPD still has your fingerprints, your arrest photo, your pedigree information, things like that. I think that's what you're talking about, wanting to get completely expunged. And that, again, is a application process. If you walk up to 1PP, they're not going to tell you anything that you want to know. So, you know.
Like
Every time 1PP is mentioned, I have a reaction. I've been trying to work on it, and I said, just why?
Okay, well, that concludes our talk. Thank you guys for joining us. Let's give a round of applause to our speakers, Jennifer and Shatad.
Thank you for having us.
Yes. So we do have refreshments downstairs. We ask everyone to join us. If you have follow-up questions for myself, any of our partners, or even our speakers, feel free to do that. Our contact information is on this really nice pamphlet at the bottom. It has our Instagram, our email address, and our website. So feel free to get in contact with us. We do these meetings. It used to be the last Saturday of every month, but sometimes it's the third Saturday of every month. So just be on the lookout. Follow us on Instagram. If you didn't get a chance to sign our sign-in sheet, please do so, because it adds you to our mailing list. So you'll be able to get our emails, our blasts, and things like that. And please join us. We have more than enough snacks for everyone downstairs. And if you have any questions, feel free to ask us. So thank you once again for coming out.
Can we also just take an opportunity to announce what's coming up next year?
Oh, yes. Okay, so we have a lot of things coming up. In October, we are going to do 3 sessions of financial literacy and planning. So if you know anyone who wants to start a cannabis business but has no idea how to go about doing so, this is going to be the first time where we're having multiple meetings in a month, and that's because we understand how important it is to walk someone through creating a lesson plan, well, not a lesson plan, creating a business plan, figuring out what your market optics are, figuring out your lane, how you're actually going to go from a thought to actually materializing something. So it's going to be October 12th, October 19th, and then November 5th. And like we said, we're going to take you from the actual inception of the thought to creating a business plan, creating, doing some pitch practicing, but it's going to be really immersive. We're going to give you homework at the end of every meeting, and then you're going to bring the homework back to us, and we're going to work with each person one-on-one to give them that feedback. So at the end of this 3-step course, you'll actually be able to make some steps on your viable business. And in November, we're going to do some we're all about financial literacy for our communities and making sure that when we enter these industries, we're actually seeing some kind of profit and we're doing something. So we're going to talk a little bit about stocks that you can invest in, because we're not going to be promoting anything like selling. We can't do that, or any delivery services. But if you wanted to learn a little bit more about investing and things like that, we're also going to discuss that in November, and we're also going to do hands-on training. So we're going to have a school come in and teach you guys how to do some trimming, how to do some dispensary skill building, so if you wanted to work in a dispensary, and things like that. So we have October planned for you all, and we have November planned. So you're going to walk away with real deal skills. Okay? Yes, we will be using hemp.
Legal
hemp. Don't, no THC. So we have a lot planned for you guys, and please join us. And those 2 trainings will be paid, but they're going to be a very nominal fee, because we are a nonprofit and we understand the community we're servicing aren't going to have excess amount of funds. So we're not going to beat you guys over the head. It's not going to be $200 or anything like that. So please sign up so we can give you more information and keep those dates in mind. Once again, thank you guys for joining us, and come downstairs for snacks. Yes, thank you. Thank you guys. I'm low, by the way. Low. I mean, it's Shaloma, but like you, I'm tired of people butchering my name. Okay, you would be surprised. I've gotten